Well, hello everyone. My name is Professor Jason Chuah, and I'm from City University in London, and I'm the head of department in the law school, and I'm also a professor of commercial and maritime law. I would very much like to say a few words about the topic of the conference today, which is about economic sanctions imposed or reimposed by the United States on Iran, and the impact of those sanctions on shipping and trade. So essentially, we know that the sanctions are very wide-reaching, they are very extensive, but also they do lack clarity, especially towards the outer edges of the regime. So we do have some concerns, of course, as to how best to tackle the issue of sanctions from a legal, commercial and contractual standpoint. I think that it is a matter for the industry to have to rise to, partly because if we are going to leave it to the European Union, for example, or other host states, that will be seriously deficient. So in my talk today, I spoke a little about how deficient the European Union blocking regulation is. What that regulation does is it tries to require companies that are based in European Union countries to disregard US sanction laws and to offer them a financial remedy if they were found to be liable for breach of US sanctions law from a civil law perspective. However, we also know that where commercial interests are to be found, where the currency for trading is usually the US dollar, and that most shipping and trading relationships tend to extend quite far and wide, that there are a good number of individuals, a good number of entities involved. It is quite difficult to say that we can avoid US sanctions law entirely and rely on the protection of the EU blocking regulation. Having said that, of course, the commercial sector has come up with some solutions. So from a contracts point of view, they have included sanctions clauses which try to provide for a remedy should either party be caught in a sanction trap, if you like. However, these clauses in themselves also face problems around how we interpret them, how we construe them, and often there is no clarity as to whether the sanctions clause themselves are going to be in breach of either US sanctions law or the EU blocking regulation, because the two systems are at the moment at opposite ends. So we've got the US law saying sanctions must be reimposed on Iran, whereas the European Union is saying you must disregard the US law, you must continue trading with existing relationships in Iran. But if, let's say, the commercial interests require you to comply with with US sanctions law, you may be entitled to some degree of compensation. So we're looking at an industry that is trapped between two poles. On the one hand, we've got the US sanction system, and on the other hand, we've got the European Union blocking regulation. And this, of course, leads to a rather unhappy state of affairs. So why this conference? Well, for obvious reasons. Iran is about 100 odd miles away from Dubai and from this region. A lot of shipping goes through this region, and there are a good number of interconnected relationships between Iranian businesses and businesses in the United Arab Emirates, and it therefore simply is a matter of primary importance, not only for shipping lawyers, but for commercial operators, for people who work in the port industry, in the supply chain industry. Everyone is going to be affected in one way or another. So the conference touches therefore on a rather important subject and a very current topic in today's times. So we do believe therefore the collaboration between the Academy of Law at the DIFC and the City Law School has brought about to the fore a subject that is of exceedingly useful but also important topicality.